This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lamsal.
And I'm Jennifer Raphael. Today we are exploring a topic that many of our listeners will be familiar with. What happens when the tender information turns out to be wrong? Our guest is Lucas Shipway. Lucas is a barrister at Greenway Chambers. He specialises in complex infrastructure and engineering disputes and has regularly appeared for private and public clients in construction matters. He is also recognised as a preeminent junior in construction and infrastructure Australia-wide in Doyle's Guide. Many of you will know Lucas from his presentation at the 2025 SoCLA National Conference, where he tackled a question that goes to the heart of project risk. How should the law deal with faulty tender information? And is there a better way forward? In this episode, we explore what faulty tender information really means and why it causes so much trouble, how courts are responding when governments try to contract out of responsibility, why causation and loss remain difficult to prove, and what a transparent, collaborative, and ultimately fairer tender process could look like. Let's jump in. Lucas, welcome to the show.
Thank you very much. Nice to be here.
Lovely to have you. Can you start by explaining what this issue is all about for those who may not be so familiar with it?
Sure. It's pretty common practice for particularly major infrastructure projects that are sponsored by governments to have a tender process for the selection of the contractor or consortium of contractors that will deliver the project. And a tender process involves information being provided by the government, in the case of a project like that, to the potential bidders. They look at that material, and on the basis of that material, they will put together their bid. Often what governments want is a fixed price bid. In other words, they're expecting the tenderers to identify the price that they propose to do the work for. There may be some negotiations once the tenderers are shortlisted, but you can see that it's very important for tenderers that they have a clear understanding of the work that they're going to do in order to accurately set that price, because once they've signed the dotted line, they'll be bound by that price. And if it turns out down the track that there's some aspect of what they were told for the purposes of putting together their tender that's not correct, or that something was missing, that can have a big impact, because it can mean that the contractor finds that it's actually got to do much more work, for example, than it thought it had to, or work that was more complicated. And it will therefore be caught where it's signed up to a contract with a particular price, but in hindsight, it would have set a different price. The reason it particularly can cause problems is because often there's an asymmetry between what the tenderers will know about the project and what the government knows about it. Because, as you can imagine, often governments will have more information about what for example, the site involves, what the work involves. There may be other government agencies that have information which will be relevant to the project. And we've seen a few examples over the years where governments, not necessarily intentionally, but they don't include everything in the information that's made available to tenderers, or there's some mistake or error in what they do include. And that then causes the sorts of problems that I've just referred to.
So when you talk about faulty tender information, then what kind of problems are we talking about? Can you give us an example of how it may play out on a real project?
A really good stark example, I think, is the light rail project in Sydney. There was a lengthy dispute after that project was underway between the New South Wales government and the contractor that was undertaking the work. The contractor complained that the tender information that it had relied on in signing up to the project didn't fully disclose all of the cables and pipes and other utilities that were under the pavement, beneath the roads and so on along the route, particularly in the CBD in Sydney. That dispute didn't ultimately go to a court hearing. Court proceedings were commenced, but the government settled the proceedings, it was reported, for some $500 million. So a very significant amount of money had to be paid beyond what the government had originally anticipated it would have to pay to the contractor as a result of that problem. There's obviously also an effect in terms of the delay to the project because the contractor was struggling with this problem of discovering additional utilities that it didn't expect, and that appears to have caused quite considerable disruption to the way it carried out the project. So that's an example of something I think which has had real impact in terms of cost to taxpayers in terms of an additional payment, but also impact for the businesses and residents along the route of the light rail by reason of the extension to the disruption from the building of the project.
Yes, definitely. And so is this something that you're seeing quite regularly in your practice, this particular issue arising on projects?
Look, it does come up from time to time. My interest in the topic has partly arisen because I was involved in a class action brought by the businesses and residents along the route of the light rail, actually. We were in the High Court earlier in the year for the latest round in that long-running dispute. That's a dispute which arises from that disruption that I mentioned to the neighbours of the project by reason of it taking as long as it did. It took much longer than it was anticipated to take, and that's, as I said, seems to have come about mainly because of the encountering of all these additional utilities. So that's partly the reason I think it's of interest to me, but it's also, I think, particularly topical at the moment that the construction sector generally is stretched. There's lots of pretty significant projects underway. We've got Western Sydney Airport, the Metro in Sydney, there's Snowy Mountains 2.0, and of course we've got Queensland Olympics around the corner. On top of that, the government and governments around Australia are trying to tackle the housing crisis. So we've got a construction sector that's really under some strain. Governments are trying everything they can, I think, to improve the productivity of the sector. And this problem with tender information is obviously something that gives rise to additional costs. It's not helping get anything built any quicker. It's just adding to the burden for contractors and for governments, frankly, because it causes these problems which have to be managed. It happens at state level, it happens at federal level. And I'm focusing here on the government projects in particular, but obviously this tender approach is an approach that's also taken in private projects. The implications are perhaps slightly less serious because you, for example, don't typically have that information asymmetry. If a private developer is doing some development on land, you wouldn't normally expect that developer to have access to some particular set of information that wouldn't otherwise be available, whereas sometimes, as I said, governments will have that access. And also you haven't got, I suppose, that immediate taxpayer impact where a project that's been priced on a particular basis turns out to cost more because the contractor comes along and makes a legitimate claim for additional payment. But this problem can also affect the private sector.
Yeah, absolutely. So your paper outlines some examples of how this issue has come to play out in the cases. You refer to the Abbey Group case in your paper, which involved a missing plan which led to an extra 100,000 cubic metres of excavation work. What does this case say about the potential liability of governments for faulty information?
It's an interesting case, that one. It arose out of the construction of a spillway at the Warragamba Dam, which is a dam that supplies drinking water to Sydney. It was a fixed price contract. The government told potential tenderers that there were no plans available of a particular embankment that was involved in or going to be part of the work. It turned out that that was false. There was, in fact, a drawing, which dated back to 1951, when I think the original dam was built, that was held on site. That drawing revealed that there was a great deal more excavation required, as you say, than Abbey Group, the successful tenderer, had anticipated. There's no suggestion that the government was withholding that drawing intentionally. It's just that it had escaped the relevant tender committee, I suppose, attention, so that it wasn't included in the material that Abbey Group and the other tenderers had seen. There was a drawn-out series of court hearings. At the end of all that, the New South Wales Court of Appeal found that because of the asymmetry between what the government knew, the fact the government had this drawing, which would have been very relevant to the tenderers, the fact that the Abbey Group had, it said, had relied on there not being a drawing available, those things, among other things, led to a finding that damages were payable to Abbey Group for the additional cost that it incurred in carrying out that extra excavation, which was like $7 million or something. And we're going back a few decades now, so it was a significant amount of money. The case is an example of, I suppose, the worst case scenario for governments in this sort of setting. It's interestingly not been relied upon on many occasions since. That might be because of the special fact, the fact that there was this particular drawing that really was very relevant but hadn't been provided. Also, I think perhaps because of the costs and time involved in the drawn-out litigation, right? Only some contractors have got the deep pockets needed to keep that litigation going. It took a number of years to get to a result. But it does show, I think, what can flow for governments if tender information is misleading, and similarly, I suppose, for private sector principals. I mean, it may well be that case and cases and like it were in the government, New South Wales government's mind when it settled that light rail case, right? Because when I'm giving advice, that case has to be taken into account. You have to say there is a risk that if someone relies on the tender information and it turns out that it's wrong, that person will be able to bring a misleading and deceptive conduct claim. That's the basis on which that case was decided. You cannot rule it out. And so, as my understanding is, that's the claim that was brought, or the nature of the claim that was brought in relation to the light rail. And you'd have to assume, I haven't seen the advice, but you'd have to assume that the government was being told, well, cases like the Abbey Group case demonstrate that you might find that a court will give the contractor the extra money that the contractor has incurred to do the work that it's turned out it has to do.
Absolutely. The decision really highlights just how significant the consequences can be when, as you point out, the government wasn't doing anything nefarious. It was simply a plan was missed in the tender information, and it had some very significant flow-on consequences in that case. One of the orthodox approaches to limiting liability for faulty tender information has been to incorporate sort of complete agreement or no reliance clause in construction contracts. Can you explain what these clauses entail?
As you say, standard approach of governments in this space, and I think it's probably fair to say it's the case with private sector principals as well, is to disavow any responsibility for the information that they provide to tenderers. And that, as you say, will take the form usually of a clause it might be in the final contract. It may also be actually embodied in the agreements that govern the tender process. Sometimes there's a separate standalone agreement governing the tender process. Those clauses are expressed in a range of different ways, but generally the essence of them is statements along the lines of, you shouldn't rely on what we're providing you. You should make your own inquiries. All we're doing is passing on information that we've got. We don't accept any responsibility for what we are giving you. We don't give any warranties about what we're giving you. And there'll often be express statements to the effect of, for example, the principal is not accepting any duty of care in relation to the information, and that, for example, it won't be liable under legal principles such as the prohibition on misleading deceptive conduct if it turns out that the information is incorrect or incomplete. So they take a variety of forms, but that's usually some or more of terms along those lines.
And then the Viterra Malt decision has obviously come along and it's impacted on the ability of people to rely upon these types of clauses. Can you explain why that is?
That case involved the sale of a business, so slightly different context. But the transaction documents included a no reliance clause very much along the lines of what we've just talked about. The acquiring business, after having bought another business, discovered that the business it had bought had been engaged in dishonest practices, which had resulted in it forming an inflated view of the value of that business. So it felt as if it had been misled. It brought a claim for misleading deceptive conduct. And the Victorian Court of Appeal detailed judgment looked at the effect of the no reliance clauses in terms of whether they excused the vendor from liability for failing to disclose the existence of that dishonest conduct. The Court of Appeal went through and in effect found that those sorts of clauses are not effective to prevent liability for misleading deceptive conduct. Statements that no representations express or implied are being made, which, as I said, sometimes is one of the sorts of clauses you'll see, they were said by the court to be of no effect when, as a matter of fact, a representation has been made. So in other words, you can't wave a magic wand and turn what is actually in fact a representation into something else. Similarly, a clause that says you shouldn't rely on anything we're telling you won't prevent liability for reliance if, in fact, someone has relied on it. Finally, I think importantly, the sorts of disclaimers that say we aren't liable for misleading deceptive conduct were held by that court to be ineffective because you can't contract out of that prohibition on misleading deceptive conduct. Now, that's a topic that's of some controversy. It remains to be heard and considered by the High Court, but at the moment, that seems to be the prevailing view. The reason it's controversial is because it's possible in contracts to do all sorts of things and to agree the terms of your relationship, and there's a view that parties should be free to, as long as they're doing so, on the basis of full knowledge, to modify their exposure under that law. But in this context, the Victorian Court of Appeal said that those sort of no reliance clauses are simply of no effect. So that's, I think, an important reminder that, a bit like the Abbey Group case, principals should be cautious about assuming that by stating in their tender information that, or their contract, that all they're doing is passing information on and they take no responsibility for it, that won't necessarily work.
Absolutely. So do these types of clauses have any residual value in these circumstances? Is there any benefit to continuing to include them in the contracts?
That's a good question. The Court of Appeal in the Viterra Malt case did recognise that clauses like this can still have some utility because they can play a role in preventing a causal connection between information and the consequences. So if there are clear statements, if you like, health warnings around information, then there are scenarios in which the defendant can say, well, it turned out that information was false, but we had said very clearly when we passed it on that we weren't sure it was right and you shouldn't rely on it. There will be cases where the person who has received that information just can't show that they acted reasonably, really, in relying on it because they were told when they were given it that it really wasn't reliable. Obviously, what that ends up shading into is a sort of situation where there isn't much utility in providing the information at all. If the information you're providing is sort of so unreliable it shouldn't be relied on, then there's a question mark as to why it's been provided. So it doesn't entirely solve that problem, but there is some utility, I suppose, in the clauses from that point of view.
And so there's a obvious tension about agencies that want contractors to commit to fixed prices based upon the tender information, but then this desire to avoid responsibility for that same information. How have courts dealt with this contradiction?
That contradiction is really at the heart of this topic, and we've seen a couple of the cases we've been talking about, I think, reflect the way Australian courts have approached it. There are cases like Abbey Group, and I suppose you might include the settlement in relation to the light rail, where the view's been taken that a contractor ought to be given some compensation because they've made out a claim. There are other cases in Australia where that claim's been brought but has failed. And so there's no clear doctrine in Australia that is tailor-made to the tender contracting type scenario. Misleading deceptive conduct is the legal cause of action that's generally relied upon. Interestingly, the position's different in the United States, where there is actually a dedicated doctrine. It's known as the superior knowledge doctrine. It essentially holds that if the government possessed superior knowledge that was vital to a contract's performance and failed to share it with potential contractors in a tender setting, the contractor that ultimately enters into the contract may be entitled to relief. Doctrine that's only available in limited circumstances. It's available in circumstances where there is that asymmetry of information, where the contractor can show that the government knew something that only the government knew, as the contractor was not able to find it out, and it ought to have been disclosed. It's a little bit like a failure to disclose or misleading conduct by silence. And the United States doesn't have a misleading deceptive conduct type of cause of action of the kind we have in Australia. So you can see that perhaps it's filling a gap that in Australia is filled by misleading deceptive conduct. But there's no consistent approach by Australian courts to this problem. It's really very much case by case, and it's, as I've indicated, it's contractors bringing claims generally relying on the misleading deceptive conduct prohibition, which is directed to consumers, but it's also directed to commercial conduct. And so far it's seemed to work reasonably well. There haven't been a great number of cases, but the ones we've seen have grappled with it with some care, I think it's right to say.
And so you mentioned these cases are not always successful. One of the difficulties associated with them is obviously proving causation. Can you explain some of these difficulties for our listeners?
There are a few, and it all depends obviously on the facts of the case. But one of the things you have to do is to prove that the defect in the tender information, whether it's something that's missing or whether it's something that's incorrect or something else, has actually been factored in or caused you to put forward a particular price. Sometimes that's a bit difficult because sometimes there aren't documents that will show that. Rather, what happens is after the event, the winning tenderer discovers something which they say, well, if I'd known this, I would have put my bid together in a different way. I would have had a different price. I would have expected to do this work instead of that work or what have you. It might be easy to say that in hindsight, but you can't then go back to your documents and demonstrate that there's been that clear reliance on what was given or that had something different been provided, there would have been a different result. That's the first point. The second difficulty that I'll highlight is that you'd have to prove what would have happened had the misleading conduct, if that's what you're relying upon, not occurred. In the Abbey Group case, the Court of Appeal concluded that what would have occurred on what we call a counterfactual is that the existence of the drawing would have been disclosed and that Abbey Group would have increased its bid price, and therefore what it gets is the difference between the price it actually put in and the price it would have put in, which would have covered it for the extra work. Now, one of the problems with that, which has been pointed out by commentators, is that it's difficult to be sure that had Abbey Group actually bid at that higher price, it would have won the job. One of the things you'll have to do if you're going to prove your case is you have to prove, well, I would have increased my price, say, and I still would have won the job. Because if you wouldn't have won the job, then you wouldn't have been in the situation in the first place. So that's the second difficulty that can sometimes arise in a causation context. That's a different transaction, no transaction distinction, as we call it. And you've got to work through that point and make sure that it's not going to be a stumbling block.
Yeah, absolutely. So with these types of cases, they're obviously expensive to run, have significant consequences, and can cause a lot of delays on the project. So what are some of the strategies that you think should be adopted to avoid this risk of faulty tender information in the first place?
These are just suggestions really, because it's not easy to pull together the information that's needed for these sorts of tendering exercises. There can be no illusions about that. Often governments are working with timelines that are difficult. There will be all sorts of external factors that will play into setting the time by which, for example, tender material has to be prepared, and then often the time the tenderers are given to consider that material will be limited and so on. And those are the facts of life which aren't necessarily easy to manage. But to the extent possible, I think there's a couple of things that are at play here. One is that point about the timeline for the tender process. I think it's fair to say that often when these things go wrong, it's because of unrealistic timelines and deadlines that are too tight. That can obviously affect the capacity to put together the material that you want tenderers to look at. It can affect the capacity of tenderers to review and digest that material. And it can affect the ability of tenderers to interrogate the material and have a communication back and forth, perhaps with the principal, to clear up uncertainties. So that would be the first suggestion, would be that where possible, that the timelines that are set for those processes are realistic. There's the obvious suggestion that the material that's pulled together is carefully collated, carefully identified. And I think in that context, perhaps the focus should be on that point about the asymmetry of information. What are the things that the government or the private principal knows that the tenderers won't know or wouldn't be expected to know or may not know or may not be able to find out? If there's information of that kind that realistically could affect the project, it seems that there should be a focus on identifying that material, it seems to me. Then I suppose finally, as I mentioned, there's a need to facilitate communication and clarification with tenderers to enable tenderers to work through points. And it may be that in that process there will be things that are raised which highlight some asymmetry or something that needs to be provided. And again, if it's possible, there should be sufficient time allowed for that to be worked through rather than having things done without sufficient time.
Your paper also proposes that agencies should acknowledge bidders will rely on the tender information and build proper valuation mechanisms into the contracts. How realistic do you think that is given current government procurement practices?
That's a good question, and I can only offer views from an external perspective, but it does seem that there has been a pretty dogged insistence by government agencies at a state level and at a federal level on this no reliance type approach. Clauses of that kind are included in the standard tender templates documents that are available online from state and federal and probably local government too, frankly. So that indicates that the approach that governments have taken to date and at the moment look like they will continue to take. I said at the start that there's a shift or a push toward trying to improve productivity, and I understand that in that context, for example, the New South Wales government is looking at its procurement processes and looking to reduce the costs of tendering. There are all these costs to the industry that are associated with putting bids together, looking at tender information, pricing their bids, submitting those bids. Obviously, the tender process carries with it the risk that you bid for something and you don't win it. So those expenses or costs when you don't win are in a sense wasted. And so in that context, it may be that the governments are looking at this and thinking about, is there a better way? It seems to me that the writing is on the wall as to reliance on disclaimer of responsibility. The misleading deceptive conduct cause of action is very much alive and well. True it is it hasn't been used in many cases, but we've talked about examples where it has been used. If a contractor can demonstrate causation and can get over hurdles like the counterfactual and so on that we talked about, then the contractor will have a claim if they can say and show that they relied on something which was wrong or incomplete. And if that's the case, then governments, it seems to me, ought to be approaching this with open eyes and saying, well, we have to recognise that the information we provide is going to be relied upon, and if there's some problem with it, then we are potentially going to be exposed for some increased cost. The same goes for private sector principals. So it may be that there is already that recognition, but it just seems to jar a little with the inclusion of these sorts of clauses. And one wonders whether there might not be a better way whereby there's a recognition on both sides, that is on principals and on tenderers' sides, that this is the reality we're working with. All we can do is, if we're offering up a project and inviting tenders, we had to do our best to overcome that asymmetry, provide the information that we think is relevant. And if it turns out that there's something that we haven't known or haven't found or was hidden in a folder somewhere, then we'll have to roll with that as that emerges, because in the end, it may be that that's actually the cheaper and more efficient way forward.
So if you were advising a state government tomorrow on how to reform their current approach to tender information, what would be your top recommendation?
I think it would be to think carefully about those asymmetries in information and dedicate some attention to that. Do your best to cure those asymmetries, that is, provide the information that will inform the potential tenderers as well as you can. I'm sure that's already what governments seek to do, but I think giving that extra priority can only help. Coupled with that would be the need, as I said, to try to be realistic about timelines and to encourage and facilitate open communication with tenderers and make the tender process as collaborative as possible. Finally, I suppose the point I made a few moments ago is that perhaps what's needed is a change in mindset, which shifts from this idea that it's possible to disclaim responsibility for this material toward a perhaps more realistic mindset, which says, well, ultimately, we are responsible for it because claims can be brought and sometimes they'll succeed, so we have to do our best. That seems to me to be potentially a more efficient way in the long run.
Well, I guess we'll have to wait and see how it all plays out in practice. But thank you so much, Lucas, for joining us on the show today.
It's been a pleasure.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawona Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.